the father of the wife who was the victim. Next, please. This was an illustration from the United States Supreme Court of how sometimes you have to use a wise legal strategy in order to determine what the philosophy of the individual judges are. In this case, the judges were not inclined to use Fourth Amendment search law, so they were much happier to use property law doctrines. And so when a police dog comes sniffing on your front porch, if they stay more than so many seconds and they engage in a search, it's considered illegal. Next. This case involved the proper interpretation, or as we say, the construction of a statute, which was interpreted for a long time to give immunity to homosexual prison guards who would rape at will male prisoners. With the proper interpretation, the guards were now liable and they were made to pay with severe consequences for raping prisoners. Next. Today we're going to talk about a theme: political truth versus absolute truth. And one of those illustrations will be um, what the government's definition of a human being is and what the real definition of a human being is. And we'll talk about the outcome in the Wagner case next. Again, the Auger versus Watcott case was a human rights tribunal case. Again, it's a contest between political truth and absolute truth. Um, and I will explain more about that case when we get to it. Next, please. Mhm. This is probably the most important recent case that's been decided by the Supreme Court of the United States. It again, the Roe versus Wade was based upon political truth as a matter of judicial legislation, as opposed to the actual truth as to what the Constitution was about and as to the history of the law of abortion was. So again, it's a contest between absolute truth and political truth. Next, please. And this is the outcome in the Roe versus Wade case. Um, the result is that now individual states elect politicians who will then decide whether they're going to be in favor of abortion or against abortion or somewhere in the middle. So I'll talk about those consequences because it's dividing the United States right now politically, and it had a huge impact on the midterm federal elections. Next. Okay, we can remove that now. We don't need the PowerPoint presentation anymore, and we'll move on with the lecture. Okay, so let me tell you something I was thinking about when we left the other day, and that was um, what I was suspecting some of you may have been thinking, um, and in the sense that there's some unspoken questions. Because you see, what happens is in North America, there's there is a question posed to people who defend clients in criminal cases, and one of those questions comes down to: how can you defend a person who is guilty? Or how can you defend such an unpopular client? Because the job of a criminal lawyer is to represent bad people. And the question then arises: do you have a choice? Can you say, no, I don't want to accept a client who is a criminal client? Well, in the field of transactional law, which involves contracts, wills, estates, commercial deals, corporations. In the transactional world, and even in the case of civil litigation, yes, lawyers are free to pick and choose their clients. But there is a tradition, an ethical mandate, so to speak, in the field of criminal law, which comes from the British common law, which comes from British legal ethics, that a criminal defense attorney may never refuse a criminal client, no matter how bad the crime is, no matter how evil the client is, no matter how horrible the facts are. Um, and the reason is um, that if you start picking and choosing your clients, what happens is often nobody wants to take on that client, and the whole system will collapse, and the right to counsel will collapse, and you can't get an adversarial trial where both sides put forward their best arguments and best evidence so that the trier of fact, the jury or the judge or both, uh, can't make a fair and reasoned decision. And so let me quote from a couple um, documents that I researched over the past week to talk about where this tradition comes from a little bit more. Now, there are, I think, two exceptions um, that 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 can come up. But let me quote from the first document. There was a um, it's considered. Let me quote from Rostow, who's an authority. This was in an article in the I believe it was in the Kentucky Law Journal, I believe it was. And what it said was this: it's considered a breach of professional etiquette to refuse to represent a client on any ground other than lack of available time. In other words, if your calendar is completely full and it would take 2 or 3 years before you can represent an individual, you are at liberty to say no. However, um, there's always an exception to that where a judge asks you in the United States to represent somebody as a court on a court appointed basis. And in that case, the lawyer is expected to give away all his existing clients to other lawyers and other firms and to do that particular case. Now, when a lawyer is sworn in um, as a lawyer in the United States, and I have been sworn in as a lawyer in the United States in 2 different states, we swear an oath. And part of that oath says this: I will never reject from any consideration personal to myself the cause of the defenseless or oppressed. Um, in other words, all defendants, however unpopular, have to have the benefit of defense counsel for their defense. So that's where this comes from. And so, but let me tell you this: what happens is when you do your duty as a lawyer, and I must say, this is something I personally follow. I don't turn down any criminal clients, but what I do is I get subject in some cases to personal vilification, loss of some clients, some social reprisals, political disabilities. As you heard in one of the cases, I lost an election because of that. I think that some law firms would not want to have me on staff or as a partner because I bring in unpopular clients, and their civil litigation or transactional clients feel uncomfortable with the firm representing people they've already made a judgment on. Sometimes things will get really bad for criminal lawyers who sacrifice themselves to obey legal ethics. and some of them have faced discipline proceedings before their bar associations. Now, so it's kind of interesting because um, there are examples where a really bad person needs a medical operation, and so a physician who performs surgery on a really bad person who is seriously ill, that physician is not subject to condemnation by members of society. Similarly, if a really, really bad person wants to see a clergy person, that is a religious person who is like a priest, like a Buddhist priest, let's say, or a Catholic priest, or somebody who's a member of the faith and who is an official of that particular faith, that clergy person is also not condemned, and people view it as a good thing that this person wants to see somebody because they think it might be a good thing if the person wants to repent. No, but even so, what the lawyers are doing, even though they're facing bad publicity and facing misunderstanding, is what they're doing is they're not just defending the client, they're defending the system. What they're defending is democracy and liberty for a fair trial for everybody. Because no, if you were not to give a fair trial to one person, it would spread through the system and it would corrupt the whole system. So I think that you may have studied Shakespeare, some of you, and I believe there is a play called Henry the Fourth, where Shakespeare quotes one of the characters saying, "The first thing we do," and this is in a situation where a political authority wants to seize power, is, and this is what they say, "The first thing we do in terms of our strategy to seize power is to kill all the lawyers." In other words, we kill the lawyers. Why? Well, it's a very good plan because it's the lawyers who are the first line of defense in favor of democracy and liberty. If you get rid of the lawyers, then you're going to have much easier time to seize power. Now, let me tell you that there was a lawyer called Stephen Jones, and he had a lot of press about his involvement in representing Timothy McVeigh. I don't know if you're familiar with this case, but it's the case of terrorism, domestic terrorism in the United States, where there was a building in Oklahoma City that had many, many people in it. They had government offices like Social Security. There was a daycare center with young children. There were government offices involving, I believe, the Justice Department. It was a very, very important building, and Timothy McVeigh left a fertilizer bomb the size of a truck in front of the building, and half the building was destroyed. The front half was totally destroyed. Over 500 people were seriously injured, and about 150 to 200 people were killed, including the fiance of a law professor who I was friends with at the time. So it was very devastating, and it was a terrible, terrible crime. Probably the worst case of domestic terrorists before 9/11 took place in the United States. So the judge called up Stephen Jones and said, "Stephen, I have decided you're going to defend this individual," and he did. He wrote about it. He said there is a duty to represent the unpopular client, and so he basically writes that the legal profession is a profession, and it's the duty to serve those who call on him. And the reason for this is because a trial is supposed to be the search for the truth, and the best means to achieve the truth is through the adversary system. And so that's why you need a very good lawyer representing the accused person and a very good lawyer representing the government in these cases. So I wanted to tell you about that, and I provided PDF copies of these articles to Professor Yang. And so, if you want, you can ask her for this if you're interested. Now, I have given you the highlights of um, those cases or those articles because I want you to understand that in criminal cases and many of the lec- lectures I've given to you involve criminal cases. It explains perhaps an answer to your unstated question. Well, why would Professor Lugosi represent such bad people? And the short answer is that's my ethical duty to do so. And so I hope you understand now um, why we do that, because it's a matter of, number one, preserving the constitutional rights. It's a matter of preserving the adversary system. It's a matter of ensuring fair trials. And it's a matter of ethical and professional responsibility. Okay, so let's move on to the matters that we are here for today. And I want to speak first about the Mary Wagner case. Now, Mary Wagner um, is in her early 40s, but she spent about a dozen years of her life from the time of approximately age 30 to try to save the life of unborn children. And why would she do that? Well, she would go to the private abortion clinics in Canada, and she would give out roses and literature saying, you have a choice. You don't have to be here if you don't want to be here. And I would like to give you any assistance through these organizations, like money, housing, any kind of assistance, so you don't have to feel abandoned by your boyfriend or by your husband, and you can do this. And when she spoke to these women, um, what she said was, um, you know, please don't kill your baby. Now, she was charged criminally for this because um, the crime was trespassing onto private property and interfering with the business of an abortion clinic. Now, at the time she did this in 2012, she there was a criminal code provision that said anyone can come to the rescue of anybody who is about to face an imminent assault. And uh, and if you believe that, like Mary believes, that an unborn human being is a human being as a matter of science and biology, then according to the law, you can use proportionate force. And the proportionate force that she used was simply the spoken word. She didn't use violence. She was nonviolent, but she used words. And in fact, words are recognizable in the criminal code as force because in a case of manslaughter, if you use words, you can provoke somebody into killing you. And those words are considered force. So, so Mary was using the most minimal amount of force you can imagine to try and talk somebody out of having an abortion. So I thought, you know what, this is a good opportunity to see if we can challenge the law. And let me tell you what the law is. You see, according to the Criminal Code of Canada, the government passed a law, and this is the national government passed a law, saying that you are not a human being unless you're born alive. Let me say that again. You are not, in law, a human being until you are born, and you are alive when you are born. Okay? So the question is, ultimately, does the government have the authority to define who is and who is not a human being? Because if you look at the other end of the human life spectrum, can the government pass a law saying if you're 80 years of age or older, you are no longer a human being and you may be killed without any legal consequences? So before you are born, you're not a human being. Then you can add to it. If you're over 80, you're not a human being. What if you've been in a terrible, terrible accident and you are so disabled, you cannot think, you cannot work, and you're just in a hospital bed the entire time? Can the government say after 1 year, if you are in such a state, physical state or mental state, you are no longer a human being, therefore you can be killed? So then you think about history. And of course, you remember from your studies Germany in the Second World War, where they passed laws saying that if you're a member of the Jewish race, you are not a human being. And therefore, it was completely legal to kill Jewish people. And then if you were a gypsy, that's also a category of people. They're also not human beings, and they also may be legally killed. And so the question is, in a constitutional democracy like Canada, can Canada simply have a law saying that the government can decide who is and who is not a human being? I suppose in some countries in the world that are not based upon the constitutional principles of Canada, maybe that's the way life is. And, I don't make any comment about that. People are entitled to decide their own laws in their own countries. But in the country of Canada, there is a constitution, and it says that um, everyone has a right to life, liberty, and security of the person. So the question is everyone, that word everyone, does that mean human being? And if it means human being, does it mean every human being is a matter of truth, biological truth, scientific fact? Now, Mary Wagner had two of the best experts in the world prepared to testify, in fact, did give a summary of their evidence to the trial judge. And they both said, these world leading experts, that when at the point of conception, when the sperm is fertilizing the egg, and there is a new human being in the form of embryo that develops into a zygote, that develops into a fetus, and then develops into a recognizable baby, that from the moment of conception, both of them agreed with one another, saying that there is a new and unique human being formed. And so there was no evidence from the prosecution to the other side. The prosecution had no evidence to say anything to the contrary. In other words, that evidence just doesn't exist because that's the biological truth. So what was the judge's solution? Well, the judge simply decided not to admit the evidence. So in a constitutional argument, there is a requirement for lawyers to put together an evidentiary foundation so that you can argue the law based upon the evidence. So the judge, anticipating what the argument was going to be, decided, okay, I'm not going to allow the evidence. So there's no evidence, therefore there can be no legal argument. And that's what they did. And then the judge also tried to change what the legal question was. The judge said there have been other cases about the personhood of unborn children, and they're all against. It's all against the existing law to say that unborn children are legal persons with constitutional rights. But nobody was arguing that, so the judge invented this, and so the argument was not that they were persons, but that they were human beings. and you think about this, when you look at the history of the United States and you look at the history of human slavery, in the 1840s, 1850s, Black people from Africa who were human slaves in the United States, they were all regarded as human beings, but they were not legal persons. In other words, they had no right to vote, they had no legal rights to be free. So they were human beings because there were penalties even for killing slaves because they were human beings. Okay. But you couldn't, they had no legal rights because they weren't legal persons. So the judge was trying to deliberately confuse what the case was all about. And so Mary Wagner's case took over 9 years to get to the Supreme Court of Canada. It took that long. And so you may be surprised it takes such a long time. And it did. And at every stage of appeal, Mary Wagner's case was lost. And I want to explain something about the Supreme Court of Canada. The Supreme Court of Canada is very political. The judges are appointed by the government. And to be appointed by the government and by the leader of the government, who is the prime minister, you have to pass a political test. So they ask you questions like, are you pro-choice? In other words, are you in favor of abortion? If the judge says, yes, I'm in favor of abortion, then they say, good, you get to be on the court. So if you're somebody who says, I believe in human rights for everybody, I believe abortion is wrong because it takes an innocent human life, a life of a person that's never committed a crime, then the political leadership says, sorry, you're not eligible to be a judge on this court. And so what the Supreme Court of Canada did is they refused to hear the case. They refused to hear the Wagner case. And I found that interesting because it exposed the court to ridicule. Ridicule is where you laugh at the court because you have lost respect for the court. Because the legal test for going to the Supreme Court is a very important issue of national importance. And when you think about it, it's a very important national issue to decide whether or not the government can decide who is and who is not a human being. And so this was the result in the Wagner case. And I mention it to you because again, truth, biological truth, was ignored in favor of the political truth. And the political truth would be if the court accepted the case and if the court admitted the evidence that an unborn child was a human being, they would have to rule that abortion was illegal. And if they did that, there would be such rebellion by many, many people in the country who want the right to an abortion, who believe they have a right to abortion. And you can see the result of the public outcry in the Democratic Party in the United States after Roe versus Wade was reversed. And so it's hard to separate politics from truth. And remember that the role of a lawyer as part of the adversary system is to discover the truth and be neutral about politics. It should only be about the law. It should be about truth and justice. But truth and justice in Canada is thrown out. Okay. And so many people are very skeptical because they recognize that in the Canadian legal system, um, the court does not value truth, at least with regard to a value that matters to them, like abortion. And I'm quoting from let's see, a decision of the of various Supreme Court decisions where they say in all these three decisions, the goal of a trial is to ascertain the truth. The goal of the court process is truth telling. And so when the court decides we're going to ignore the truth, it shows that they're hypocrites. So they will pick and choose which truth they want and which truth they don't want. And so it makes one very discouraged as a lawyer who is who is taught or teaching others how important truth is to the legal system when the court itself is morally corrupt and they don't have integrity. And that's my view, and I'm entitled to say that in this Canada, uh, in this country. But that's what the Wagner case was all about. So let me talk to you about the Auger versus Watcott case. Um, Watcott was a person who um, valued truth, and he was very upset that there was a political candidate running in an election in the Vancouver area, a person who was born in France, who was um, born a man and biological man, and when he at some point in his life, he this individual who was born a man became politically active and was all in favor of transgender rights. In Canada, they have have laws that permit people to identify with a sex other than what they have been born with. And so people are free to take hormone therapy, people are free to engage in surgery, and people are free to retain all their body parts and retain their hormones, but just simply dress like a member of the opposite sex. Now, in this particular case, um, um, the person known as Auger dressed as a woman, demanded to be addressed as she, demanded to be recognized as a woman, and according to the law, was entitled to be recognized as a woman. Now, some people didn't take kindly to that, and among them was Mr. Watcott. Watcott says, "You're a liar. You are untruthful. The reality is you're running for political office. You should be a person of moral integrity, telling the truth. And you're pretending to be a woman when you're really a man. You, in fact, have two children. You had a wife, and you dressed like a woman. You're just pretending to be a woman, probably because you're mentally ill." Well, that didn't go over too well because, first of all, it was not an easy election. And Mr. Walcott was distributing literature. You know, his arguments were on paper, and he was going door to door trying to influence voters to vote against Auger. And so the question it was really in a political election, is there free speech? Is there freedom of expression um, to say don't vote for an individual who is a public figure, who has given up their privacy to be a candidate running for public office, and who is an advocate for transgender rights? And so, uh, after the election, which resulted in the defeat of Auger, who was not elected, Auger went to the British Columbia Human Rights Commission and filed a complaint saying two things. The first thing was by publishing and distributing literature, it exposed Auger individually and transgender people generally to hatred and contempt. That was the first charge. And the second charge was you have discriminated or intended to discriminate against transgender people with regard to gender identity or expression. And so Watcott was represented by me, as I was Mary Wagner's lawyer, I was Walcott's lawyer. And I advanced the argument that he had a constitutional right to say the candidate's morally unfit to hold public office. And we said that the moral life of a candidate is a legitimate ground to question somebody. And you could go further. If somebody is mentally unstable, is mentally has a psychiatric condition, then maybe that's even more evidence why somebody should not have power as an elected official. Well, of you know, the Human Rights Tribunal, let me explain this. The Human Rights Tribunal are employees of the government, and the government is very pro transgender, very pro LGBTQ, that is lesbian, gay, transgender, queer, that whole constellation, and more of people who self identify as members of what's known as the Pride community because they have marches called Pride marches. So, the argument, the main argument I advanced is that if you have freedom of expression at all, it is most protected in an election. Because if you're choosing a candidate running for public office, democracy requires public scrutiny of the moral fitness of every candidate. And if you go back in history, you'll see, for example, all kinds of allegations that this particular candidate, don't vote for them. They were cheating on their spouse. They were unfaithful. They were having sex relations with their secretary. You talk about the moral integrity of Trump. Apparently, he was with a prostitute at one time or somebody like this. And they're saying, don't vote for Trump. He is not morally fit. Or, you can think of any number of scandals where politicians are involved in moral corruption and that sort of thing. So, um, some people argue it doesn't matter. As long as they can do the job as a politician, who cares what their personal life is? If they want to if a man wants to marry a man and have sex with a man, that should be his freedom to do so. Other people say, I don't feel comfortable with that. He's not a normal person, but in this country, the liberal attitude is um, that there's nothing wrong with saying that you want to be um, recognized as a woman, even if you were born a man. There is a story, a piece of literature by an author called Anderson from Europe. He talks about the emperor's new clothes. It's a children's story. And the basis of the story is that there was once an emperor who was very vain and arrogant. He was full of his self importance, very big ego. And so this emperor decided to have the finest clothing in the world. And his tailors fooled him into being completely naked, into being without any clothes at all. And they said, "Oh, Your Majesty, you have the most beautiful clothes. You just cannot see them, but you have the most amazing clothes on." And the very naive and gullible emperor said, "Oh, yes, I have the most amazing clothes." So he had a parade. He went into the public. He marched up and down the streets, and all the people who he ruled said, "Oh, Your Majesty, what beautiful clothes you have. What amazing clothes." And then there was a little child who pointed the finger at the emperor and said, "Hey, look, the emperor has no clothes." So it was the child who spoke the truth, but everybody else was so intimidated and afraid to say the truth. They were all pretending and going along with this crazy notion that the emperor had clothes. Now, why would Hans Christian Andersen write such a story? I think in his day, and this was like 200 years ago, whenever he wrote this story, I guess he was trying to say that people should tell the truth, and sometimes the only people with the courage to tell the truth are children because they don't know how to lie. And so, we used this story at the hearing, but nobody gave that story any credibility. But I think that's a very good analogy of how um, you know uh, how what the situation was really all about. Now, Watcott lost. He lost, and another lawyer was to do the appeal. But he unfortunately was negligent and he missed the deadline for filing the paper, and that's the end of the appeal. And in some ways, maybe that's a good result because it's a very low level precedent that is against freedom of speech in the public place. And there's an interesting legislation out right now uh, called strategic litigation lawsuits. For example, if if OJ now today were to sue Watcott and say, you know what, I'm suing you for defamation, that is for libel and slander, uh, because you said that I'm really a man when I'm self-identify as a woman. If he did that, this legislation would allow Watcott to use this law to say it's in the public interest for me to be able to say these things as part of my freedom of expression in society, and therefore your lawsuit against me for defamation must be thrown out. Now, the interesting thing is you cannot use that law, which is called a SLAPP law as an acronym, you cannot use that law against a government agency like the Human Rights Commission of British Columbia. You can't do it. And so it's rather unfortunate because the only remedy is to throw out the civil action. But an administrative law proceeding before the Human Rights Tribunal is not considered a civil action or a court action. It's considered an administrative law action. So that sounds a little complicated in some ways, and perhaps it is. But I just wanted to let you know that here we have basically the suppression of free speech. And one thing I wanted to mention is a couple quotes on on cases from the Supreme Court of Canada that the Human Rights Commission completely ignored. In a case called Switzman, which was a much older case, um, the judge on the Supreme Court of Canada said, in another context where homosexual, transgender rights were not at issue, is the province or the federal government, neither one of them can take away the right of discussion and debate. And here's the important point. Political free speech is the lifeblood of democracy. Political free speech, like the air itself, is not confined to the physical limits of a building where people debate, but extends everywhere. It's a treasured political institution that, at its highest level of importance during an election campaign, when the freedom to choose a candidate is at stake. I couldn't have said it any better than that judge. And another judge in another case, Chief Justice Duff, said in reference re Alberta statutes that every point of view is legitimate in both the advancement and the attack upon political proposals. And there's no limitation, according to the Supreme Court of Canada. So I believe if that lawyer hadn't been negligent and got in this case went to the Supreme Court of Canada, I would have thought Walcott would have won. But again, there's a practical problem. Watcott had no money. I was with a law firm who refused to let me continue because I was not self-employed at that time. I was a contractor for them. And they said, no money, no case. And that's what happened. So, and there's no legal aid for somebody like Watcott to pay for this. In criminal client, yes. This discrimination, human rights client, no. And here's the last thing I want to tell you before our break, and that is Chief Justice Duff said this: democracy cannot be maintained without foundation. Free public opinion and free discussion throughout the nation of all matters within the limits set by the criminal code and the common law. The government cannot interfere with somebody's right to fundamentally express his opinion and discuss matters of public concern. The reality is, with this low level decision by the Human Rights Tribunal, all these wonderful, bold pronouncements about democracy and about freedom of expression are gone. In other words, there is no freedom in a public election to state your personal opinion about the moral fitness of a candidate. And so, whatever you may think about Canada as a wonderful country with democracy and freedom of expression, the truth is the the courts would rather believe in fiction and political truth rather than reality being biological and scientific truth. So ask yourself this question: is Canada really that good when they ignore absolute truth in favor of political truth? So that's a big problem we have here in Canada, and I wanted to let you know all about it. So I think it's time for our health break. So let's pause for a little bit and then we'll come back with the last lecture. All right, everybody, it's time for our final lecture in this series. And it's going to be about the case of Dobbs versus Jackson Women's Health Organization. And let me tell you what happened before this case ever went to court, because the history of this matter is, I think, very interesting for you. Um, I attended graduate school at the University of Pennsylvania beginning in the year 2000. And during the time I was there, I intended only to take a master's degree in law. And I was fortunate to have some very good training by some excellent professors. I don't know if you're familiar with the University of Pennsylvania, but it's in the Ivy League. It's in the same caliber and the same league as Harvard, Yale, Columbia, New York, and other schools like Chicago and Stanford. Those are all excellent schools, and Pennsylvania is always in the top 10. So I went there primarily because they also had a degree offering in bioethics, and some of the other schools did not at the time. Harvard did not, Yale did not. So I went to Pennsylvania. So while I was there, I I studied about Roe versus Wade, which was decided in the 1970s, the early 1970s. And this is the case that held under the um, privacy law and the due process law that abortion was legal, and the court set up a trimester system. And so that case was followed over time by a case called Casey and other cases. Roe itself followed a case involved called Griswold, which was about contraception. And so um, the interesting part was when I was studying, I was reading the judgment of Blackmun, who wrote the majority judgment in Roe versus Wade. And he made a comment in his opinion to the effect that, of course, if the unborn child was a legal person, the whole case for abortion would collapse. So I thought about what he said. I thought, what does he mean? Can an unborn child be a person? Because coming from Canada, as I did, the idea of personhood does not emerge until after the child is born. But apparently, American law has a different way of looking at things. You may assume that Canadian law and American law are essentially the same in many respects. And yes, there are some similarities, but in the area of abortion law, they're very, very different. So when I looked at personhood, it was clear to me that there was a case to be made that an unborn child was a person under the American Constitution, even though that was not possible under the Canadian Constitution. And so I was wondering, well, I want to read about it. Who's written about what Justice Blackmun said about the whole case for Roe versus Wade would collapse? In other words, the legal justification for the ruling in Roe versus Wade was vulnerable. It was susceptible to being reversed, in other words. So I said to myself, I'm going to do some research. And as much as I looked in the year 2000, nobody had written about it. Nobody. There were comments and articles about other aspects, but there was no law review article that explained the vulnerability of Roe versus Wade and how it could be overturned. And so, I thought about it for a while, and then I put the idea away for a couple of years because I decided to take a degree in bioethics the following year. So I got my first degree from Penn in 2001, and then 2002 I graduated with my bioethics degree, and I decided at the end of 2001 to apply both to bioethics and for the PhD program at Penn. And it was very, very competitive because they only took one or two students out of the entire class. And I was faced with a choice because I got accepted into both the PhD program called Doctor of Juridical Science, and I was accepted also into the bioethics program. So I did the bioethics first because it required residency, and I specialized in pediatric medicine. And so I spent time at one of the world's leading children's hospitals, the Children's Hospital of Pennsylvania. And so it exposed me to a lot of things going on in terms of organ transplants and euthanasia, as well as all kinds of other ethical issues. And abortion is part of bioethics in the sense that abortion is within the scope of study for bioethics in terms of is it ethical? Because bioethics means essentially do no harm to a patient. And then you ask yourself, who is the patient? And so I was trained in both the medical bioethics as well as the law. And then I got into the PhD program, and then I had to come up with a thesis. So I checked the literature again because I was curious about Roe versus Wade, and I found out that nobody had yet written about that. And I was thinking, gosh, if I write about this for my dissertation, I'm going to be a pioneer in this field. And if I'm going to do the job, I better do it right. So I put a proposal together for my supervisor and for the committee, and it was accepted. And I must tell you that the University of Pennsylvania is a very progressive liberal school. And people who were in favor of abortion were very happy to be there because their ideology was very similar and fit into the existing intellectual thought. People who were questioning the morality of abortion, which is what I was about to do, and the legality of abortion, which is what I was about to do, would be considered um, outside of the intellectual group that was favored. And my committee consisted of a Black woman who was a feminist, who was a Democrat, and two other Democrats who were both Jewish men, who were both activists in the ACLU, the American Civil Liberties Organization. And all three of these people were associated with Planned Parenthood and advocating in favor of abortion. And so it was kind of interesting that my committee members were all ideologically opposed and opposite to what I was proposing. I mentioned this in the put everything in the proper context because um, when I was in the bioethics class and studying the most important subject, my professor was that Black woman professor who was the feminist, the member of Planned Parenthood. And so for my class project, I chose the separation of conjoined twins in England, which these young babies were joined by the chest and the abdomen, and the doctors determined that if they were to be separated, that then one of them would die for sure. One of them would live, the other would die. So they went to the court, the highest court in England, for a ruling in advance of the operation because they didn't want to be charged with murder because these children were already born. And so it was a very interesting analysis that I put onto this thing. And the Black law professor woman uh, was so impressed with my project, she couldn't resist but tell the class that, oh, and by the way, one of your classmates had not only completed the project, he had the project published and he's going to be my research assistant for the summer. And so we became friends despite our ideological opposing viewpoints. And so I had to delay my dissertation for a little while because my daughter was very, very sick with bacterial meningitis. And the same place where I interned at the Children's Hospital of Philadelphia was where she was in hospital for over a month. And so I was taking care of my family, and so I had to abandon my work and defer my project, my PhD. I had to defer it until the fall. But in the fall, I started my first job as a law professor, and I was teaching in Florida. So during the day, I was learning the course and I was teaching the course. And in the evening, between 6 o'clock and 2 o'clock in the morning, I'd be doing my PhD dissertation. And every morning, I'd be up at 8 o'clock in the morning, where I'd be working through till about 5 o'clock in the afternoon. So it was a very grueling schedule for 2 years. And I finished my dissertation in 2 years. And I had, first of all, an agreement with Yale to publish it, which was the most prestigious law school there at the time. And but you have to understand that the law journals are run by the students. The students are the editors. The students are the ones who choose who gets published and who doesn't get published. Now, there was a time when the students who chose my article, my dissertation to be published, they were replaced by a new group of students because the ones who wanted my article graduated, and the new group of students who came in didn't want to publish my work because they didn't agree with my position for political reasons. So they refused to publish my work. So I had to go to another journal, a much lesser prestigious journal, to get my entire dissertation published. And then I had a condensed version published by Georgetown University, which was a rather respected journal. And I published a condensed version there of my dissertation, the most important parts of it. So in a way, it was a little better because I split the work in half. So, but let me tell you what I did. I went through the history of Roe versus Wade. I went through the history of personhood. I went through all the legal doctrines, the legal philosophers. I went through American legal history, British legal history, abortion law history, and I showed the way to overturning the false assumptions and the misstated facts in terms of whether or not there's a constitutional right to an abortion. So I proved there was no constitutional right to an abortion in the beginning, from the very beginning. And I did that in my dissertation, and I was the first one to do so. And then it was very interesting because I decided then, if there's medical evidence, because remember, I was trained also in bioethics. So then I decided, if there's medical evidence to show that an unborn child is a human being, then we can show that under the Equal Protection Clause of the 14th Amendment, that everyone deserves equal protection from all the laws, which means if an unborn child is a human being, not only is it a person, but under the 14th Amendment, it's entitled to protection from murder. Therefore, if that argument were to be accepted by the court and properly interpreted to be such, then all abortion would be illegal in the United States based on the federal Constitution, the national Constitution, which applies not only to federal laws, but all the state laws. So that was my dissertation, and I vigorously defended it before my committee, who, of course, were very, very critical and had a very tough scrutiny of my dissertation proposal, because these were among the leading intellectuals in the United States who were all in favor of abortion. So they would only pass me in my PhD if I had absolutely perfect arguments. So they attacked me on various grounds, and they asked me to rewrite a couple parts to make my dissertation stronger, which I did do. And I graduated, and I was the only one in my class who graduated in 2005. Nobody else. I was the one and only class of 2005 in the doctoral program. The other student had failed. So, so anyway, that's some history. But it was interesting that at the time, my Black law professor did two things that showed how fair she was, despite her own personal intellectual preference. What she did was she nominated my doctorate as the best dissertation in the United States for 2005. I did not win that award, but it was very nice that she did nominate me. And the other thing she said was this. She says, in my classroom, when I teach about abortion, I have never found any solid intellectual argument based on legal history that would be worthy of giving to the class. She says, your material that you have now published is the only one I'm going to use in my class for an opposing viewpoint. So I was touched by that. I thought that was very, very nice of her to recognize my work. And so this is what happened. I went on in my teaching careers, and over the span of about 3 years, I published about 14 different articles, and I got some very good evaluations, and I designed a few new courses, and I had a very successful 3 years where I was teaching in Florida. Um, and uh, so what happened, I think, was that about 5 years or so after I published my dissertation, um, I noticed there was an article written by a Harvard law student in one of the journals at Harvard, and he copied most of my work, but didn't give me proper attribution. In other words, he committed an intellectual crime known as plagiarism. So I contacted him and I complained, but he didn't even have the courage to write back. He just stole my work, basically. And but his work, no, it got some attention because it was under the name of Harvard. So people started circulating his work. And then another professor, a more esteemed older professor, who had transferred from Yale to a town to another law school in the Midwest. He also stole some of my work and started quoting some of my work too, without attribution. And I wrote to him too. So I want you to know that intellectual theft is very common in the United States. And I've experienced that firsthand. But notwithstanding all that, um, eventually my arguments that were first presented were basically being copied by a lot of people, and then I realized that there was a whole bunch of personhood movements in the various states, and like the state of Georgia and other states, where they were trying to pass constitutional amendments, state constitutional amendments, to bestow personhood to the unborn child. So it's quite interesting to see people in the United States were forming a great big movement following my dissertation. And so it was quite interesting when the state of, I think it was Missouri, where Dobbs arose, um, decided to pass a law saying at 15 weeks you cannot have an abortion. And they initially didn't try to reverse Roe versus Wade, but eventually that argument emerged. And so that case had many, many, many interveners from various public interest groups, those in favor of abortion, those against abortion. And I met some of those attorneys when I went to a conference near Los Angeles just a few weeks ago. And I asked him, did you use my work? He said, and the lawyers, they all said the same thing. They said, not only did we use your work and read your work, we put it before the court. And as you know, they won their case. Roe versus Wade was overturned. Now, I sent to Professor Yang a syllabus, which is sort of like the Supreme Court's version of a head note to her for distribution to you of the U.S. case. I did not send my dissertation because it's very, very long and it has other materials in there that would not be helpful to you. But that's why I'm giving a more elaborate history, more elaborate dissertation. But here's the thing: what was different about my proposal and my blueprint to overturn Roe versus Wade was remarkably different in the outcome of what the Supreme Court decided to do. You see, originally there was a judge on the US Supreme Court called Scalia, who I suspect was murdered in Texas um, while Obama was president. And Scalia was a very, very talented man, but they didn't do an autopsy, and there was a lot of secrecy over what happened to him. But Scalia was the brightest, most brilliant man on the court, the best writer on the court, and so on. But Scalia and I had a disagreement. We spoke about it actually. I believe because I had met him on a couple of occasions, and his plan was to return the matter of abortion to the states. And I said that's legally wrong. I said you need to use the 14th Amendment to make abortion illegal, because that way you have one law in the entire country. But his view was different, and we agreed to disagree. And so what happened is when Justice Alito, who is nicknamed Baby Scalia because he's younger than Scalia, but he has the same kind of thinking, he wrote the majority opinion in the case of Dobbs, and he basically followed Scalia's ideas to return the matter of abortion to the states. And so at first, the public outrage was overwhelming. People thought abortion's going to be illegal throughout the United States, and indeed, if my plan had been entirely adopted, not just halfway adopted, abortion would have been illegal in the United States. And yes, I would anticipated there'd be a lot of very unhappy people there. But the reality is the court made a political compromise. The political compromise is that each individual state can elect the people they want, and then they can decide if they're going to keep abortion legal, make abortion illegal, or make some kind of compromise law down the middle somehow. And so what happens now is you have what we call red states being Republican states and blue states being Democratic states, named after the political parties. So let's say in California and New York, you can have all the abortion you want to have. But let's say you go to Missouri or Texas or some other place, abortion would be illegal at 15 weeks. And some of the states are trying to make it illegal from the time of conception. But that's a very small minority of states. So what it is that there's a split, a political split. So some people are relocating in the United States. People who are living in red states are moving to blue states. People who are living in blue states are moving to red states. Some people aren't moving at all, and they're just driving to the other state if they want an abortion or not. So it's really has divided the United States politically, really, really badly. And give you a good example. When the midterm elections were held less than 2 weeks ago, the candidates for Senate and the candidates for the House of Representatives, the Congress people, they uh, they were, a lot of the people for the Republicans were chosen by Trump because Trump is now running again for president. And so these are Trump's people, and they're blaming Trump because many of these people lost. And they're saying, oh, no, we need to have DeSantis or some other new leader for the Republican Party. Well, I'll tell you why they lost. It had nothing to do with Trump. This was a voter reaction to the Dobbs decision because many of the people were interviewed coming out of the polling booth and say, why did you vote the way you voted? And the people said, I can't believe it. My constitutional right to an abortion has been taken away. I blame Trump for this. He picked judges that were conservative and so on. So it's a political backlash involving abortion. Now the interesting thing is, and the very sad thing is, there was never a constitutional right to abortion to begin with. There's no right to abortion in the text of the Constitution. There's no right to privacy in the text of the American Constitution. It was a political invention made by the court to accommodate the women's rights movement. And this is the saddest thing because people had an expectation that the law was the law and it was based upon solid legal ground. But the reality is, it was never on solid legal ground. And in fact, the leading intellectuals who in favor of abortion all admitted that the Roe versus Wade was vulnerable, that it could not stand. And the best argument they had was based upon legal precedent to say that based upon the principle of stare decisis, which is a Latin term, which means there's a previous decision that you have to follow. Um, they were saying, please, it's been so long, we cannot change the law. Well, you know what? There was a case called Plessy versus Ferguson about a separate but equal doctrine involving Black people and white people. And that came from the South many, many, many years ago. And about 50 years later, in a case called Brown versus Board of Education, they said that this doctrine of separate but equal is never going to work. It has never worked. And we need to have integration. We need to have black and white people go to school together. We want to have our children play together. That's the only way we're going to get rid of racial discrimination. Saying we're going to have separate facilities for black kids or white kids, and we're going to give them the same equal opportunity for education. That was just a lie because the reality was, the white kids had a much superior education than the black kids, and they were never equal to begin with. It was just a fiction, a legal fiction. And so I used actually in my dissertation the Brown versus Board of Education case overruling Plessy versus Ferguson. I said, you can overrule, it doesn't matter how long it takes to overrule it, you can overrule it you know. So what the argument the Democratic lawyers were arguing was simply, it's been too late. Even if Roe versus Wade is bad law, bad constitutional law, the people expect it to be true. The people think they have a constitutional right, and you can't change the law after so long. But the Supreme Court of the United States says no, it's never too late if it was never legally correct. And they used the Brown versus Board of Education to justify that result. So anyway, I want to mention that to you because there's another case that Justice Black tried to do in the 1940s, and that was the case about corporate personhood. In the 14th Amendment was designed to have equal protection for people, not for corporation. And what happened is there were railway companies in the 1870s that were trying to get some rights under the 14th Amendment, and there was some corruption politically and judicially. And so Mr. Justice Field nudged the law along. He was on the US Supreme Court at the time, and he was from California. And what he did was he sort of moved the law in the direction of giving corporations legal personality the same as a natural human being under the 14th Amendment. And so they finally got that. And so corporations were vested with human being rights under the 14th Amendment to get equal protection. It was never intended for that, never. And it was very bad law. And so Justice Black in the 1930s tried to change that law about let's see, about 50 years later. And the court at that time said, no, 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 it's too late. We're not going to let you do that. It may have been wrong, but we're going to let corporations get away with it. Well, the reality is corporations, as you know, are very, very powerful. And some people say the US government today, no matter which political party wins, is governed by military and industrial corporations that are in favor of wars, in favor of war machines, and so on. And these are the ones who are benefiting from the billions and billions and billions of dollars allocated for the Ukraine war. And so these corporations are getting very, very, very rich, and there's no accountability of where the money is being spent. And so they're just going to authorize another $37 billion. Yeah. So, I mean, it's just a crazy, crazy system that they have in the United States. But in the area of abortion law, the US Supreme Court decided at least to reverse Roe versus Wade, despite the fact it was a very, very old case, just like Plessy was an old case. But they wouldn't reverse the case uh, in the 1930s of corporate personhood. And if you try to do it today, they'll argue, well, you know what? It's been over 100 years. Now it's way too late to reverse the granting of legal personhood to a corporation, even though from a matter of intellectual integrity and as a matter of constitutional law, corporations should have never been given rights under the 14th Amendment because those rights were only intended for human beings, natural human beings. So I just wanted to digress and show you that the court has now gone into a situation where you have abortion states, non abortion states, and compromise states. And most of the states are pro abortion, and most of the states are the who are left are pro compromise. So there's only very, very few states that are pro life, if you want to call it that. Now, there was another kind of situation in the 1850s in the United States. And what happened in the 1850s, um, there was something called the Missouri Compromise. You see, the United States was expanding its territories from the Atlantic Ocean over to the Midwest, and finally they're extending themselves into past the Mississippi River, into Missouri, into Texas, into other states on the other side of the Mississippi. And so, what the slave states like Alabama, Georgia, South Carolina, and so on, they recognized unless there was a line drawn between North and South, there would be more free states than slave states, and they could lose the right to have slaves. And so they made a compromise politically with the federal government. They said, okay, if you are below a certain geographical line, then you are a slave state. If you're above that line, you're a free state. And so the compromise resulted in a divided America, which turned out to be the North versus the South, which turned out to be the Union versus the Confederacy. And if you know your history, you know that the Union, the North states, where slavery was illegal, ended up in a civil war with the Southern states where slavery was legal. And so you may think that the Civil War was all about uh, the morals of slavery, but it was never about that. In fact, President Lincoln said uh, that he would be in favor of retaining slaves if it would save the country from a civil war. So it wasn't that at all. But what it was about was state rights. In other words, the individual states who volunteered to join the 13 colonies, which formed the country of the United States of America, they retained sovereignty. They were sovereign nations unto themselves as states. So they could come up with their own laws. They had independence and their own sovereignties. And so they said, if we decide not to have slaves, that's our choice. You can't force us. This is a matter of our constitutions, our laws, our traditions, and so we're not going to agree. And so they had votes in the different states as to whether or not to make slavery illegal or not. And I think they were determined, if I remember some of the history, that over time they would eventually get rid of slavery on their own. But they didn't want to do it right away because the economies were different. The South was big on agriculture and the North was big on manufacturing. Now I'm generalizing, but in a sense, that's where it was. Like, for example, guns were manufactured in Connecticut and New Jersey. That's where the Colts were made, the Colt weapon, the Colt 45s, and those other kinds of weapons that they were using it during that time. And the South, they didn't have any place to manufacture guns, but what they were doing is they were growing cotton. That's where clothes were being processed, and they were making furniture, and they had other trade that they were engaged in with other countries around the world. So leaving aside the history lesson, the the point of all this comes down to this: you had a divided America over a very important legal issue that resulted in a civil war. The reason I'm mentioning that is that we have moved forward now 150 years or so, And now we have a divided America all over again. So we have what I call the Dobbs Compromise as opposed to the historical Missouri Compromise. So we have a very, very evenly divided America, which is prone to having its own civil war. The country is politically unstable right now. You know, there's all kinds of accusations of voter fraud. So election integrity is a big issue right now in the United States. Nobody knows whether the elections are rigged or not. There's been stories and movies about vote dumping and mail-in ballots. And all of a sudden, in places where the Republicans are winning, they shut the polls. They reopen the polls to count what's just arrived. And all of a sudden, the Democrats are winning by huge margins. How can that happen? And so many people have voted that it's beyond the number of people who are allowed to vote. And you wonder about all the illegal immigrants coming in from Mexico, and they're all voting Democrat, and they're not even legal. And so there's all kinds of problems here. And so you have a lot of very unhappy Republicans who are ready to pick up their guns and fight because they think the election has been stolen from them. And then you've got the government having all kinds of SWAT teams and paramilitary operations. And then you have the Democrats saying, if you don't like the election results, you're an enemy of the people. Well, it's all setting the stage for an American Civil War. So I say this because the Missouri Compromise failed over the issue of slavery and states' rights. And I predict that the U.S. decision in Dobbs, which is another compromise, setting up abortion states and non-abortion states and those in between, that's also going to fail. I just can't see it. And the solution was quite easy, and I proposed the solution in the 14th Amendment. Everybody who's a human being is entitled to equal protection of the law under the 14th Amendment, and therefore the innocent shall not be murdered. They have the protection by laws against homicide, and therefore abortion is then illegal in the United States. And so this is where it's going. And the reason I gave so much time to this one particular case is because who knows what the future is going to bring. But unless the court revisits the institution of abortion, the question of abortion, I fear there's going to be civil violence, even short of a civil war in the United States. I think it's a very volatile issue. It's a very emotional issue. And people think they've been wrongfully deprived of a constitutional right, but it was an imaginary constitutional right that was never founded upon the law. So you know, it's something that really is valid. It's something that's currently probably one of the biggest legal challenges facing the United States of America right now. And I wanted to give you this insight. And so, what I want to do is give some time for questions, some a little bit of extended time, because it is the last lecture in the series, and I want to make sure that you have all the opportunity to ask questions about the American position on abortion, the Canadian position on abortion, about the laws in favor of transgender identity, so people will sacrifice the truth in favor of political truth. So I wanted to give you that, and I'm also willing to answer questions about legal ethics, about the duty of a lawyer to accept every criminal case that's offered to them, because that's the only way to keep the system strong and have integrity for this system to make sure it works. So I turn it over to you, Professor Wang. If you want to lead off with a couple questions, that would be great.
Oh, hi, Professor. Thank you for your insightful and wonderful lectures coming all along this way. So you can hear me, right?
Yes, I can hear you loud and clear. I'll also,
S-
I'll also look at the chat to see if there's any questions there. I don't see anything other than the distribution of articles.
so
And
maybe they are preparing because I think some Chinese students they prefer to using very uh, uh, accurate words to describe their questions. So they may need some time to prepare. So I will try to kickstart the question sessions by raising my own question. Uh,
yes,
so um, my first question is, what do you think about the different interpretation philosophy concerning the constitutional interpretation? According to my understanding, um, so some judges prefer using originalism um, to interpret the United States Constitution, and on the other hand, some other, especially those liberal or progressive judges, they prefer using the evolutionary manner to interpret the Constitution. So, what do you think about this different philosophy? Actually, from my personal understanding, I respect the originalism, but I also wonder, is that for my personal understanding, I think originalism put much emphasis on the past. It's a backward looking. Uh, uh, I personally support forward looking. So maybe that is a little bit different from your philosophy. I do I'm very curious about uh, your understanding on this issue.
I'm really glad you asked that question. It's interesting that my dissertation focused on the actual legal history, what was actually accurate, and so what I was critical of the court in Roe versus Wade did not take an originalist approach, though the judges like Scalia and Thomas and some of the more conservative judges are vetted for the Supreme Court on the basis of originalism. In other words, what was the original meaning of the Constitution at the time? I was actually correcting the legal history, which is neither originalistic or progressive. Um, but my second half of my dissertation uh, about using the 14th Amendment based upon scientific reality that the unborn child is a human being, which is an innocent human being who has not had any due process, and saying that that person is entitled to equal protection. That is not an originalistic approach. That is a modern progressive approach. In the same way, the Warren Court and the Brennan Court and the Stevens Court. So I use a liberal approach personally, and just like you do, Professor, in terms of what is the proper interpretation of the 14th Amendment to this problem of abortion in terms of equal protection. And so it may be that some of the judges on the court, which is now dominated 5-4 by conservative type judges, they didn't want to go down the second half of my dissertation. They didn't want to accept my 14th Amendment argument. They'd rather go back to the originalistic approach and say, well, let's see what the states decided in the old days and let them decide what they want for the new days. And so it may be that originalistic approach was actually uh, the approach that rejected my solution to achieve national unity on the topic. And so it's kind of ironic because I would be taking a liberal solution and end up with a conservative result. So there you go.
Thank you. Thank you for sharing your thoughts, and I will definitely read your articles. more thoroughly. And my second question concerns the function or the role of the Constitution. You depict a scenario that United States are in is a divided country right now, and also you say that Supreme Court is highly political, and the selection of the judges are highly political, and but according to my understanding of Constitution, a Constitution itself is a political document, and so every country have different political environments, so they have different constitutions, and so my concern is that facing such divergence, such divisions in their society, uh, uh, so how can Constitution play a positive role in narrowing down such gaps, such division, so people can come together, communicate, and reach consensus, not stay in their polarized political ideas. So how can the society become a united community, not different tribes that fight against each other? So what's the how can Constitution play a positive role in healing such trauma in the society?
That's a very good question too. Um, do you want me to answer in terms of the Canadian Constitution, which is different than the American Constitution, or do you want me to start with the American Constitution?
Well, probably American because it's more polarized right now.
Okay. Okay. Look, the American Constitution was derived at a time of a revolution. The primary constitutional instrument, it was actually the Declaration of Independence. And even though it's not a constitutional document per se, it plays a major part how you interpret the U.S. Constitution that was adopted. And the U.S. Constitution that was adopted, which was followed by the Bill of Rights, which are all the amendments to the Constitution, um, are basically is the skeleton on which all other laws give are based. In other words, like if you think of the human body as a skeleton, the flesh, the skin, the organs, everything else is added to the skeletal structure. In other words, the foundation and the fundamental values of that society are based in the Constitution, and it's meant to be specific enough to be understood and to have some meaning, but not too specific, but also ambiguous enough to be meet future needs in terms of the broader application of what the Constitution's about. So it's a delicate balancing act in terms of the vocabulary and the words that are chosen. And so does a Constitution, I mean, the ultimate question you ask is, at some point, you tear up a Constitution if it no longer reflects the reality of the country, where a country is coming apart at the seams. Well, that's happened where there's a revolution. People have torn up the Constitution. But the Constitution of the United States is very unique in the sense that power is derived from the people. And the people, we the people, are the authors of the Constitution. It's people based. In other words, the power comes from the people, and the government is divided. So not one branch of government has absolute control. So you have the president who has some control, you have Congress who has some control, and you have judges who have some control. And there you also have the media that have some control, not in terms of pronouncing the law, but in terms of its overall influence and the free expression of ideas, especially if you think of the First Amendment and the freedom of the press. Now, after the American Civil War, the states' rights were considerably weakened, and the United States emerged as a very, very strong federal based country. So most of the power shifted to the federal government and has never been given back to the various states. Initially, the balance of power was supposed to be relatively equal between the states. But now the power is concentrated in Washington. And in contrast, you look at Canada, where they originally intended to have a strong federal government, but now the provinces are becoming stronger and are becoming much more independent and have so much more jurisdiction than anybody could have imagined. So it's kind of ironic how you can have a constitution in 1867 for the people who decided to be loyal to the United Kingdom, loyal to the British Crown. And then you have a constitution following the US Revolutionary War where people are rebelling against the British Crown. And so you had opposite results as to what was originally intended. Originally intended strong states' rights and a weak federal government in the states. And then Canada, you're supposed to have a weak national government, sorry, a weak provincial governments and a strong national government, but everything got reversed. It's kind of interesting if you follow the path. But how do you handle a situation where you have a lot of division within the country? Well, I suspect the U.S. Constitution will remain intact because it does stand for the principles, the eternal principles of freedom, liberty, um, and the individual rights. And and people are very adamant, whether you're Democrat or whether you're Republican, they still believe in the fundamental precepts of the Constitution. I think there is still some unity over that. What tears the country apart is basically the issue of what is moral and what is just. And what you have is basically a cultural revolution, in a sense, where people who are belonging to the Democratic Party have divorced law from morality and have decided that everybody can make up their own minds as to what morality to follow. Whereas people on the other side believe in absolute standards of right and wrong. And their sense of morality is that we all know what's right, we all know what's wrong. And the one side says absolute truth, that's the Republicans, and the other side says, well, truth is relative. The truth is what an individual believes the truth is to be. So you have basically a cultural divide more than anything that's sparking the political division, and the fighting is getting very bitter. Whereas in Canada, you have basically an overwhelming, maybe 80 to 90% of the population is very much like the Democrats. They very much accept the Cultural Revolution, where they are not religious, where uh, they are basically very accommodating to immoral, what would be considered immoral in times past. The irony is Canada's really opened its doors to a lot of immigrants, and many of the people who are immigrating to Canada from Muslim countries and from Asian countries have many conservative values. And so it's interesting that the population they expect that will support them politically uh, is moving away from the Liberal Party and tending to support other political parties that have more of a moral position on domestic issues. So it's kind of interesting, but the Canadian Constitution still has the king as the head of state now that the Queen has died. And it's still a constitutional monarchy in so many ways. And it's almost impossible to change the Constitution of Canada to become a republic because it would require basically unanimous agreement by everybody. And the indigenous peoples who have many important land claims for billions of dollars, they are relying upon legal doctrines from the British Crown. So they don't want to lose their legal cases because they don't want to lose the money they believe they are owed. And so they want to keep this place in Canada, a constitutional monarchy, so that they can get money from the government. So it's quite very, very different. And I do this comparison to show that there's more of a unity in Canada than there is in the United States. Now, having said that, there's a strong feeling of Western alienation because the people of Alberta and Saskatchewan, especially, have been used as victims of colonization, not by England, but by Ontario and Quebec. So they've been sucking out the oil, sucking out the gas, and the people have been economically exploited. And now they want to go to green energy, and they want to shut down the fossil fuels. And so they don't want to have that. So now they're talking about either declaring independence and breaking free of Canada as an individual country, even though they would be landlocked, or they would be joining the United States, where they see a chance for more freedom and to be part of a more progressive country that fits in with their ideology. So there's so many interesting shifts politically, legally going on. It's really hard to put my finger on all of it. But I think that in terms of social division, political pressure, political division, it's all impacting on the law because, the federal judges in the states are appointed by those in power. The federal judges in Canada are appointed by those in power. And so you have a legacy left behind by political leaders of people who are sympathetic to the political views, and they're prepared to sacrifice legal, biological, scientific truth, reality in favor of legal fiction and political truth. So it's really hard to teach this to law students because it gets quite complex.
Thank you. Thank you for analyzing the paradox and embedded in both countries. It's very interesting.
Yeah.
Any other audience have questions for Professor Lugosi? You can just turn on your mic and speak out.
Yes, and I'm more than willing to sit an extra 10 minutes to give more people a chance to speak, given it's the last lecture. I do welcome questions, and I think that's a very good way to learn. I don't understand the question from Jenny.
I think she asked if you have any comments on the case about Huawei, Meng Wanzhou. Yeah.
Or the Canadian case about the arrest of the chief financial officer for Huawei?
Yeah.
Yeah. Okay, I think I understand. Yes, I followed that case, and it seems to me that the Canadian government was acting as the puppet of the American government to arrest this individual. It seemed to be very unfair. Seemed her charter constitutional rights as a visitor to Canada were violated. I felt that I wasn't privy to all the confidential information or all the evidence in the case, but I feel uh, that the judge was basically saying, I'm not going to release this individual because the Minister of Immigration has the ultimate say as to exercising discretion. I thought it was perhaps being evasive of the responsibility the judge has, but I don't practice in that area of law. And so I don't know whether or not the judge was properly limited in terms of the judge's jurisdiction. But the judge was making that excuse, it seems to me. And of course, she was released only after a deal was made with the Americans. I really felt it was a blunder by the Canadian government because it seems to me it was more a political case than a legal case, and that and I and I think Canadians ought to be embarrassed. And it's just another series of embarrassments by an incompetent leader of this country who is more like a child and doesn't deserve to sit with the adults. But people in this country have the liberty to vote for a child if they want, and they got one.
So Mo Wanzhou's case is a high-profile case, especially for Chinese people. So actually, maybe for many law students, they actually uh, pay attention to the Canadian legal system for the first time due to this case.
Well, yes, I think that it's unfortunate that this was the kind of introduction that they received to the Canadian legal system. And I would think that if people were upset, they had a right to be upset. But I think that it would have been useful maybe to have a Canadian legal commentator with expertise in that particular area of law be on the media and explain the case and explain the law and explain the evidence so that people would not come up with any wrong assumptions and so on. In this country, everybody is presumed innocent until they're proven guilty. And unfortunately, there's a presumption of guilt in terms of how the executive person from Huawei was dealt with. And but I think it was at least a good thing that she was not detained in jail. I think that it's a good thing she had some at least limited freedom. I think there was a lot of resentment in Canada because around the same time there were a couple of Canadians held by the Chinese government, and there was some kind of political um, exploitation that Canadians were perceived going on. So they felt offended by what was going on in China. I don't know the facts. I don't know if these people from Canada were guilty of espionage or whatever, but it seems to me that the whole thing came down to more of a political situation than a legal case. But I do know that some of the lawyers personally who were involved in the Huawei case in Vancouver, and she had very brilliant lawyers helping her out.
So I think I saw the time is up for this whole lecture. And if
Okay.
no more case from the audience, we really want to thank you again and for this wonderful uh, uh, lecture for six lecturing whole. And
Mm.
especially every time you need to, it's very late time in Canada. So after a long day work, you give us such a well prepared speech. Thank you very much, Professor.
Well, that's very kind. And Professor, I want to extend my thanks to you and for Dean Hahn for enabling these lectures to happen. And I certainly hope that your students who become lawyers will be models of integrity, good ethics, and be of good character. And I don't know if you're aware of this, but my ancestors actually came from Northeast China, and as they migrated across Mongolia, across Central Asia, um, I have a very mixed DNA as a result of that, but I still have DNA that says I'm Chinese, believe it or not, whether I look Chinese or not. So I'm very happy to share any knowledge that I acquired over time with you, and not just knowledge, but I hope I also shared wisdom, which is different than knowledge. So I'm really grateful, and I believe during every time we meet, you asked some very probing, very uh, illuminating wonderful questions that allowed me to explain a few things, and your questions have really been valued and well thought out. Thank you, Professor.
Thank you. We will cherish that blood connection. Yeah.
All right. Well, thank you, everybody, again. And I appreciate all of you who came to listen. And I hope that in some small way I've been able to add to your education. And I wish you all well. Bye for now.
Thank you. Bye.